period of time, the up or out rule. And a man was put out of the military because he didn't satisfy the requirement. But he objected because he said that women were given a longer period of time to satisfy the requirement. They were treated differently, preferentially, and he made an equal protection case. Well, the government defended the differential treatment successfully by saying that this was like an affirmative action plan for women because women have so fewer opportunities than men to make grade, to make promotion within the military, that the only way to treat them fairly was to give them a longer period of time within which to make it. But in upholding affirmative action plans, the government can't just come in and say, oh, this is an affirmative action plan. The government has to prove its case, has to prove it's a real, bona fide program. It's not just a snap that they come in and say, oh, this is a benefit for women. And in that regard, there's the case of the Mississippi University School of Nursing versus Hogan. Hogan was a man who wanted to go to the University of Mississippi School of Nursing, but the school said women only. It was a gender discriminatory law. But the state came in and said, okay, it's gender discriminatory, but wait, we can meet mid-level scrutiny. We can meet it because this is an affirmative action program. We're giving special opportunities here to women because of the general discrimination that they suffered in higher education over many years. But the court said in that case, speaking to Justice O'Connor, it said, you know, you can have affirmative action programs for women. They can survive mid-level scrutiny, and we have some of those on the books, but this one really doesn't fly. It would be one thing if the state here were offering an affirmative action program in areas where women have been underrepresented in education, for example, in engineering schools. But this program, the court said, is nothing more than an after-the-fact, ad hoc justification based upon the stereotypic notion that women are appropriate candidates for nursing and men are not. And so it rejected this idea, this after-the-fact attempt to justify this program as a bona fide affirmative action program. The second area where the court has upheld discrimination based upon gender are a few cases where it has said that there are real differences between men and women that justify treating them differently. There are two cases that are particularly interesting in this regard. The first is Rosker versus Goldberg, which is the male-only draft registration case. The court has upheld the law that says that men only have to register for the draft, women don't. Now, how did it uphold this law? Well, first, there was a lot of talk in the case about deference to Congress in the area of military affairs. But second, and what was really important in this case, is that what was not an issue in the case, was the fact that women were barred from combat. And so, in writing this opinion, and in applying mid-level scrutiny, the opinion was written by Justice Rehnquist, and his idea of mid-level scrutiny is not exactly the same as some other members, but he said he was applying mid-level scrutiny. He said, in this case, Congress could have concluded that in order to register people for the draft, what Congress was really doing was starting the first step in a process that would lead to putting an army in the field in time of need. And since draft registration was a part of a whole process to put an army in the field in time of need, Congress thoughtfully and carefully could distinguish between men and women, because what was not an issue in the case was the fact that women were barred from combat. And Congress could distinguish between men and women because only the men could be put in the field for battle. So, the court said, the government could limit draft registration to just those persons who could then and there and immediately be placed in the field for combat. And so there was a real difference that separated men and women in this context, and the court has upheld draft registration for men only. Another case of real differences is Michael M. versus Superior Court. In that case, the court upheld a statutory rape law applicable only to men. A male could be convicted of statutory rape, that is to say, intercourse with an underage female. It's consensual, not forcible rape. But a female could not be convicted under the law. And the court upheld this law, again, because it found a real difference between men and women that could be taken into account, and that was not stereotypical or based upon broad-based, generalized notions of differences between men and women. The objective of the law, the court said, was to prevent unwanted teenage pregnancies. And, the court reasoned, since only women face the natural deterrence of suffering an unwanted teenage pregnancy, you could have a law that treated men differently than women, because the women would have the natural deterrence of pregnancy, whereas the males would not. And the court added, separating the women from the men in this regard would give the extra advantage to the government of having the opportunity to have at least half of the people involved in this activity available to testify against the other half. Now, these are not particularly satisfying rationales, and in truth these cases may be more readily explained by the unwillingness of some members of the court, and maybe it's similar to the unwillingness of society, to really enforce equality between men and women all across the board, including such things as sexual relations and military service. But nevertheless, to conclude, the court has said that in looking at gender discrimination on behalf of men or women, it will apply mid-level scrutiny. And almost always, that will mean, but not always, but almost always that will mean that laws treating men and women differently will be struck down. Now, in this regard, one closely watched recent case where discrimination between men and women did not survive mid-level scrutiny was United States versus Virginia. There, the United States government challenged Virginia's operation of the Virginia Military Institute, VMI, as a male-only college which provided special, indeed extraordinary, educational opportunities for military training and civilian leadership, and where that school was limited to men only. Women could not go to VMI. Now, in an opinion overturning this, the court ruled 7-1 that this was unconstitutional. It was 7-1. There was one justice missing, Justice Thomas. He recused himself. His son is a student at VMI. The majority opinion was written by Justice Ginsburg. Justice Ginsburg said that the government must prove the need for gender discrimination at VMI, and that such proof must be exceedingly persuasive. Moreover, the proof must show a genuine, not a hypothetical, invented, or after-the-fact rationale. And of course, Virginia couldn't rely on overbroad, stereotypic generalizations of different talents, capacities, and so on of men and women. On that approach, the court said first, Virginia did not show that VMI was originally established or subsequently maintained with the goal of setting up many different or diverse educational opportunities within the state, and that was just one. Rather, the school had been carved out simply as a special kind of education limited to men only. The state also tried to argue that VMI's male-only rule should be upheld because VMI's so-called adversative method of education, involving strict discipline, no privacy, humbling of individual egos, etc., provided educational benefits that couldn't be made available in the same form if women were admitted. And it said that alterations to accommodate women, which all agreed would have to be made at least to some degree, if nothing else in terms of physical privacy issues, that if these accommodations were made for women, it would change the special method of education and ruin the unique character of the school. The court acknowledged that it was uncontested that some changes would have to be made to accommodate women. But the court also said, and this was the key, that it was undisputed that neither the state's goal of producing citizen soldiers, and that was in fact the state's goal in having VMI, nor VMI's methodology of training, neither of these things were inherently unsuitable to all women. And it wasn't enough for Virginia to rest on generalizations about women, some women, many women, because in fact there were women, some individual women, male, female, would be the same in this regard, who could make it at VMI. And the court said that women's successful entry into the National Service Academies is proof of that. So the male-only VMI admission